When spouses divorce, dividing their property usually requires classifying items as either separate property owned by one spouse or community or marital property owned by both spouses. Classification is important because, in most states, courts can only decide the distribution of community property. In re Marriage of Frick, we explore some of California's classification rules. Jerome Frick owned and operated the Mikado Hotel and Restaurant. He also owned the real estate on which the business was located, which was subject to a mortgage. After Jerome married Hiroko Frick, he used community funds to pay down that mortgage. Jerome later incorporated the business, making it its own legal entity. He then leased the real estate to the business. Jerome deposited the monthly rent payments into his personal account, where they were commingled with community funds. Jerome then paid his monthly mortgage payments from that account. The mortgage payments were always less than the deposited rents. When Jerome and Hiroko later divorced, they disputed, among other things, the separate and community interests in the real estate, which had appreciated in value. The trial court held that the real estate was Jerome's separate property, but because he used community funds to pay down the mortgage, the community had a $600,000 interest in the property. Jerome appealed to the California Court of Appeals, and Hiroko cross-appealed on other grounds.